chemical sensitivities and your rights to long-term disability benefits. I think multiple chemical sensitivity cases tie together our theme for today's podcast. And I'm going to talk about how the lack of diagnosis and ability to work in other medical facilities doomed an urgent care physician's claim for Unum disability benefits based on multiple chemical sensitivity. So let's take this apart. The first thing is that a disability policyholder or plan beneficiary has the burden to prove that they are disabled, as that term is defined by the terms of the policy of the plan. And that can be particularly difficult in multiple chemical sensitivity claims and claims where the medical condition might be disputed or not generally accepted in the medical community. What is multiple chemical sensitivity? It's unrecognized, it's controversial. It's characterized by chronic symptoms attributed to exposure to a low level of commonly used chemicals. The symptoms are often vague, nonspecific, including fatigue, headaches, nauseousness, and dizziness. Now, there are several theories that attempt to explain the cause, ranging from allergic reactions to neurobiological sensitization. And I am an individual who is highly sensitive to perfumes, colognes, laundry detergents, other things. I actually have an anaphylactic reaction and sometimes have to go to an emergency room. It's so bad that if I have to do live events, like do a deposition, be in person for mediations, we send notices to the court and to the other parties and the court reporter saying, don't wear cologne, don't wear perfume, be careful about how you've washed your clothes, because I will lose my voice and it's game over. I mean, I can't talk, I can't breathe, and it lasts for at least 8 hours. So I get what this is about, but I obviously have objective testing that establishes the basis of my reaction. But let's talk about you. What are the typical disability policy terms in a MCS claim? Now, most long-term disability policies define disability as the inability to perform the material and substantial duties of the regular occupation because of sickness and injury. There are two critical elements in this definition: material and substantial duties and the existence of a sickness. Disability carriers are typically going to begin their evaluation in determining whether you have a recognized sickness, and that's often defined as an illness or disease, but it may not be in your disability policy or plan. Now, for MCS cases, this is where you face a challenge because many insurance companies or plans will question the legitimacy of the diagnosis itself. So they will say, you don't have MCS. And that can be difficult to prove because there's no objective basis for many reactions to workplace exposures, whether it's cleaning agents, fragrances, chemical irritants, sanitizers, pesticides. Many physicians don't recognize MCS, and insurance companies often have position statements disputing the condition. And what they will also dispute is the inability to perform occupational duties. So even if you establish symptoms, the insurance company or the plan is going to scrutinize your medical records to determine whether you can perform the material and substantial duties of your occupation. Now, what they're going to argue is that you could work in a different environment without chemical exposures, particularly if the policy defines occupation as it's normally performed in the national economy rather than a specific location. And that would be the case if I were to file a disability claim, because I can work in my office or in my home in a controlled environment and attend these events generally by Zoom. So I'm not exposed to anything. So how does this work? Let me tell you the story of Dr. McFarland. It's McFarland versus Unum Life. And McFarland was an urgent care physician who had a specific reactions at one facility, but he was able to work at others. He didn't have a clear diagnosis, and with evidence showing that he could perform his job in alternative environments, Unum denied his claim. So what did the court do? Well, the court said, look, we don't see a diagnosis, and we don't really see an objective basis for the restrictions and limitations, and we are absolutely confounded by the ability to work in other settings, but not in this particular facility. And in view of that, we think that you're not disabled, because if you worked in all these other facilities, you wouldn't have these symptoms. Whew, okay. That's too bad for the doctor, but let's talk about the takeaways from these types of claims. Navigating claims for MCS or any disputed illness requires detailed medical documentation, hopefully of the diagnosis, detailed medical documentation of restrictions and limitations, including testing, functional capacity evaluations, CPET exams, any objective basis that can establish the intensity, duration, frequency, and nature of the symptoms and their impact on your ability to do your own or any occupation. That, of course, requires a vocational opinion, because at the end of the day, while a disputed diagnosis can add complexity, presenting a thorough and complete record and objective basis for the restrictions and limitations and the occupational impact can maximize the chance that your benefits are awarded. But you've heard me go through the laundry list of things that need to be proven. These are not the kind of cases that should be handled on your own or handled by someone who is not an expert in ERISA disability or understands these particular types of conditions. It requires a thorough review of the policy and plan. It requires a thorough review of the medical records. It requires a strategic approach to how you are going to approve either an objective basis of the diagnosis and or an objective basis of the restrictions and limitations. It's going to be dealing with your physicians and having conferences with them and getting, hopefully, letters of support explaining why you have the diagnosis or why you have the restrictions and limitations. It's going to require a vocational report to try to tie it all together. It's going to require statements from you, family, friends, colleagues. It's a whole package. It's just not, I'm going to file the claim and they're going to pay benefits. That doesn't happen in these types of cases. Got it? Well, thank you for tuning into this week's episode of Winning Isn't Easy. If you found this episode helpful, please take a moment to like our page, leave a review, and share it with your family and friends. Join us next week for another insightful episode of Winning Isn't Easy. Thanks for listening.